Hi, friends. This is Shahzeb from VisaWise Consultants and Lawyers. As a matter of introduction, I'm an advocate High Court in Pakistan. Formerly, I've been representing clients in the UK, being an Office of Immigration Services Commissioner Advisor at Level 3. Today's video is talking about the application processes for spouse applications from outside the UK, and it is also directed towards um, friends who want to change their career from different legal fraternity to coming down to becoming an Office of Immigration Services Commissioner Advisor. I understand that there are assessments that you need to take. So I will try my level best to come to the basics of the immigration rules while discussing spouse applications from outside the UK. A separate video will be prepared for applications for further leave to remain, if, for instance, you are present in the UK, so that you will be able to benefit from it. So, without wasting any of your time, I will start with the training session today, and we'll take it from submitting the applications to processes of how to complete application forms, what are the basic rules, so and so forth. Right. So, in order to establish that which relevant immigration rules deal with the spouse visa applications, we need to establish that these are present in Appendix FM of the immigration rule. Appendix FM of the immigration rules, they are primarily dealing with applications to be submitted for spouse applications from outside the UK. We have established that there's an entry clearance application that has to be submitted. The prime requirement for this application is that the applicant must be outside the UK. So that means that you are in your country of residence or in country of your nationality, and your sponsor is based in the UK, or the sponsor is also based in your country of residence, and you want to either join your spouse in the UK, or you accompany your spouse to the UK for this particular application. The next point here is that the applicant must have made a valid application for entry clearance as a partner. So when they say valid application, you need to come to the relevant link that is provided on the Home Office website. You can simply Google either an entry clearance application as a spouse or a further leave to remain application as a spouse of a British citizen, and you'll be able to come to this point where you click this link, and this will take you to the relevant page where it asks you to apply as a partner or spouse of a British citizen. Next page tells you whether you are inside the UK or outside the UK, and based on your presence or the country of residence, you will be able to click the relevant link, and you'll be able to then apply as Appendix FM partner. You can see here they also mention Appendix FM child, but primarily today we are talking about only spouse visa applications. Going forward, I'll be able to prepare an application or a video for yourself to understand what Appendix FM children applications relate to. So going forward, they will ask you again, as I was saying, the nationality, country of nationality or residence. You need to click that. If you are in Bangladesh, India, Pakistan, whichever country you are, you can select it from here, and then they will ask you if you have identified the location where you have to provide your biometrics. So that means that if you are in a specific city of that country where you will have offices related to the partners of Home Office, which is primarily either VFS or other providers who provide the services of accepting your application, scanning them through, and sending it through to the Home Office. So you will need to select that location where you intend to take your biometrics or enroll your biometrics. for that matter. Next, it will ask you to again apply as a partner. So you can just click on apply now here, and it will take you to the next page where it asks you to start a new application. If you have already started your application, you can say open another application if you're applying for dependents, so and so forth. So for the first time, of course, you will be starting a new application. So you can click on this tab and start your application. Now here you can see they require you to have an email address, and you create a registration ID through your email, and it takes you to the application where you need to complete your application. Here you can see there are steps towards the application. So in this section of the application, you will of course tell the Home Office about your personal identification information, information relating to your family. It also talks about your past immigration history. Have you ever traveled outside the UK, or have you ever traveled to UK in the past? If you have traveled to other countries, for instance, Australia, Canada, or whichever countries you have visited, they will ask you this information in this section. Then it talks about also your relationship with your partner. In this section, you will tell them as to how long have you been in relationship with your partner, whether your relationship is subsisting, whether it is genuine. All these questions will be asked in this section. Then you go towards finance, in which they will particularly ask about the source of income of your spouse or your sponsor. In this application, you can choose to tell them whether your sponsor is employed or self-employed, so and so forth, and they will then ask you for the relevant evidence to establish what source is your husband's or your wife's in the UK, and you will be able to identify that. Then it talks about documents. Of course, they will give you a checklist of documents that you need to submit with your application. At the VFS centers in the country of origin or the country of nationality, you go with the paper file, or you can also upload relevant documents at a relevant portal that the Home Office will ask you to upload the documents. Then you simply click on the declaration. You just confirm that everything that you have spoken about yourself and your sponsor in the application, all the information is true to the best of your knowledge and belief. Then you pay for the relevant fee for the application, which is at this point 1,564 pounds, something like that. You also need to pay what we call immigration health surcharge. So it is an application you are intending to have 2.5 years worth of visa. So in accordance with that, you will have to pay 624 pounds each year upfront, and that will be taken from your debit or credit card. Then here you can see it says further actions that you need to do. At this stage of the application, you will download the application that you have submitted online, also a checklist of the application, the documents that you need to submit. It will also ask you to book an appointment for the enrollment of your biometrics. So this, from there onwards, it will take you to a different portal where you can give your information in order to book your appointment in the country of nationality or residence. Um, so this is basically it, the application that you need to submit. Now, coming to the next part of the immigration rules, we have been here whether a person has made a valid application or not. Next thing that they need to establish is that the applicant must not fall for refusal and under any of the grounds in section SEC, suitability entry clearance requirement. So in order to establish what suitability is, let's see in this relevant space where they have talked about the immigration rules which deals with suitability requirements. Suitability requirements are mainly to establish whether you have a good character, whether you have made any past misrepresentation to the Home Office. So all these points needs to be ticked before you go and speak about the other requirements of the immigration rules. So suitability starts from SEC 1.1. It says that the applicant will be refused entry on the grounds of suitability if any of paragraphs 1.2 to 1.9 apply. So 1.2 states that the Secretary of State has personally directed that the exclusion of the applicant from the UK is conducive to the public good. So this public good factor is paramount to establish whether the person who's submitting the application has a good character. He has never been abused or has never abused an immigration rules in the past or frustrated the immigration control in a way that it does not establish that you are a person of good character. And it also talks about deportation factors. The If there is a deportation order, like for instance, a person was previously in the UK, committed a crime, and the Home Office requested the applicant to leave the country, that could establish whether there was a deportation order or whether there was an administrative removal of the person. But where there are factors of criminality, the person is supposed to leave the country under the deportation or deportation regulations. Then it also talks about uh, uh, the person not being conducive to the public good because they may have been convicted of an offense for which they have been sentenced for a period of imprisonment of at least 4 years, or they have been convicted of an offense for which they have been sentenced to a period of imprisonment for at least 12 months but less than 4 years, unless a period of 10 years has passed in the end of the sentence, or been convicted of an offense for which they have been sentenced to a period of imprisonment of less than 12 months, unless a period of 5 years has passed since the end of the sentence. So it depends as to when the person was convicted, how long was the sentence, whether this person has now conducted himself to be a better person or not. But these are very difficult situations where a person has already been convicted. It will establish whether the Home Office may be able to grant such a person an entry clearance in the UK, only looking at the good character reasons or grounds for the applications to be established. Next, it says the exclusion of the applicant from the UK is conducive to public good because, for example, the applicant's conduct, including convictions which do not fall within paragraph SEC 1.4, character, association, or other reasons make it undesirable to grant them entry clearance. So it again has to do something with the character of a person who's submitting the application. It could also deal with a different kind of police character certificates outside the UK, or in the UK it is disclosing barring services that you need to have your DBS taken. That actually also establish whether there is a previous conviction on part of the applicant or not. Then it also talks about if the applicant has failed without reasonable excuse to comply with the requirement to attend an interview, maybe in the past application, or provide information as required of the applicant, or provide physical data, or undergo a medical examination, or provide a medical report. So majority of the applications which are more than 6 months length of stay, you need to do a tuberculosis test in some part of the world where, like for instance in Pakistan or in other parts of the world, there is a requirement that you need to take a tuberculosis test. So that is what they're saying. If you have not taken that test, then you may not be eligible to pass this suitability test under the immigration rules. Then it talks about it is undesirable to grant entry clearance to the applicant for medical reasons. So if you have got some medical problems that are transferable to other public people or any national or people who are residing in the UK, then it may be that your application may not be accepted. The applicant left or was removed from the UK as a condition of caution issued in accordance with Section 22 of the Criminal Justice Act 2003, less than 5 years prior to date on which the application is decided. It also talks about the considered that the applicant parent or parent's partner possesses a risk to the applicant. That person may be considered to pose a risk to the applicant if, for example, they have a conviction as an adult, whether in the UK or overseas, for an offence against a child, are a registered sex offender and have failed to comply with any notification requirements, or are required to comply with a sexual risk order made under the Anti-Social Behavior, Crime and Policing Act 2014 and have failed to do so. So primarily what suitability requirements are that you need to not have a criminal background, or you must not have been deported from the UK, or you must not have misrepresented with the Home Office in any degrading way, that you tried to conceal the information from the Home Office. All these factors are available online on the Home Office website, where you can have a read of it before you plan to submit an application and establish whether you meet the suitability requirements or not. Um, Without wasting any further time, let's just move on to the next bit of the rules, which says that the applicant must meet all of the requirements of Section ECP, eligibility for entry clearance as a partner. So let's have a look on the eligibility requirements application for the spouse visa applications from the country of residence or the country of nationality. And then section SEC 1.9 states that the Secretary of State considered that um, the applicant's parent or a parent's partner possesses a risk to the applicant. That person may be considered to pose a risk to the applicant if, for example, they have a conviction as an adult, whether in the UK or overseas, for an offence against a child, are a registered sex offender and have failed to comply with any notification requirements, or are required to comply with a sexual risk order made under the Anti-Social Behavior, Crime and Policing Act 2014 and have failed to do so. So anyone, the partner of the applicant's parent or the applicant's parent himself, if they have convicted of such an offence, that they may be considered that they pose a risk to the applicant. Now, the next section says the applicant will normally be refused on grounds of suitability if any of paragraphs SEC 2.2 to 2.5 apply. 2.2 states that whether or not, to the applicant's knowledge, false information, representation, or documents have been submitted in relation to the application, including false information submitted to any person to obtain a document used in support of the application, or there has been a failure to disclose material facts in relation to the application. Now, this is a very serious suitability grounds that I have seen over the years, where a person sometimes forget to produce the relevant information, or if they have submitted an application through a representative and somehow they have submitted a false document that was not genuine. In circumstances like these, the applications can be refused and an applicant may be given a 10-year ban not to enter in the UK, provided if they believe that they did provide the correct information or the documents were not forged. In those circumstances, You can submit applications at the first tier tribunal if you have been given a right of appeal. And there are other pathways available for such applications too. The next section says that uh, a maintenance and accommodation undertaking has been requested or required under paragraph 35 of these rules or otherwise and has not been provided. So, if they require further information and you do not provide it within the relevant time frame, your application can be refused. The exclusion of applicant from the UK is conducive to public good because within the last 12 months prior to the date on which the application is decided, the person has been convicted of or admitted an offence for which they have received a non-custodian sentence or other out-of-court disposal that is recorded on their criminal record. So now this factor is where in some certain applications you are required to submit a police character certificate if within the last 12 months you were convicted of an offence for which you may be required to establish that you do not pose a risk to the public at large, or in view of the Secretary of State, the person's offending has caused serious harm, or the person is a persistent offender who shows a particular disregard of the law. So you need to be very careful about any past criminal convictions within the last 12 months of the date of application. Sometimes you do not give more focus to small criminal offenses such as traffic offenses or overspeeding. So you need to be very focused on all the relevant documents you need to produce if you have been convicted of a minor offense even, so that you could establish that you meet this suitability requirement. Then it says that the applicant may be refused on grounds of suitability if the applicant has failed to pay litigation cost awarded to the Home Office. So this is primarily for any litigation that you might have dealt with in your past stay in the UK, or you might have not paid the relevant litigation cost, which is primarily out of the judicial review proceedings most of the time when the Home Office has to be paid for any litigation costs that they might have incurred, where you may not be able to succeed in your judicial review application. So, need to make sure that if any of the such cost is still due towards the Home Office, you pay it prior to submitting your application. And at the last suitability requirement, it states that the applicant may be refused on grounds of suitability if one or more relevant NHS bodies has notified the Secretary of State that the applicant has failed to pay charges in accordance with the relevant NHS regulations on charges to overseas visitor, and the outstanding charges have a total value of at least £500. So if you owe any money to NHS, it is advisable that you pay that cost first before you initiate your application from outside the UK, because it may have impact on your application if these dues have not been paid to NHS. Right. So the next relevant law talks about the applicant must meet all of the requirements of Section ECP, eligibility for entry clearance as a partner. So eligibility may have different factors, which includes your relationship with your sponsor, or the financial requirements that you need to meet, or the English language requirements that you need to meet. So we will be elaborating to the very basic rules on those eligibility requirements. So the starting point here, you can see that the applicant must provide a passport or other document which satisfactorily establish their identity and nationality. To meet the eligibility requirements for entry clearance as a partner, all of the requirements in paragraph ECP 8.1 to 4.2 must be met. So all these requirements has to be met before you are granted your entry clearance as a spouse in the UK. So, first and foremost requirement is your relationship requirement with the sponsor, which states here that the applicant's partner must be a British citizen in the UK, subject to paragraph Journal 1.3 subsection C, or present and settled in the UK, subject to paragraph Journal 1.3 subsection B, or in the UK with protection status, or in the UK with limited leave under Appendix EU in accordance with paragraph Journal 1.3 subsection D, or in the UK with limited leave as a worker or business person under Appendix ECAA extension of stay in accordance with paragraph Journal 1.3 subsection E. So this section here primarily talks about the sponsor stay in the UK. It could be a British citizen who is the sponsor in the application, or someone who has got, and it also talks about someone who has got protection status in the UK. That primarily means that your sponsor has previously made an asylum application, or he might have been granted status in the UK on the basis of humanitarian protection in the UK. So, first of all, you need to establish that your sponsor meets the definition of this relevant rule, which is paramount. If your sponsor do not have any status which is mentioned here in the UK, then you may be able to submit another sort of application, like being dependent of someone who is temporarily in the UK, but this section will not be for you, and you will have to look at different other immigration rules which are applicable to your applications. Next, they says that the applicant must be age 18 or over at the date of application. The partner must be aged 18 or over at the date of application. So need to make sure that both of you are above the age of 18. You yourself being an applicant and your sponsor being the citizen of Britain, or someone who has got indefinite leave to remain in the UK. Then it says that the applicant and their partner must not be within the prohibited degree of relationship. So prohibited degree of relationship has already been defined on Google. If you could just look at that there are different prohibited relationships that you should not be in before you submit the application for entry clearance in the UK. Then it says that the applicant and their partner must have met in person, that they might have met in person before they decided to submit an application. The relationship between the applicant and their partner must be genuine and subsisting. If the applicant and partner are married or in a civil partnership, it must be a valid marriage or civil partnership as specified. If the applicant is a fiancé or proposed civil partner, they must be seeking entry to the UK to enable their marriage or civil partnership to take place in the UK. Any previous relationship of the applicant or their partner must have been broken down permanently unless it is a relationship which falls within the paragraph 278 one of these rules. And if the applicant is a fiancé or proposed civil partner, neither the applicant nor their partner can be married to or in a civil partnership with another person at the date of application. The applicant and partner must intend to live together permanently in the UK. Now, these regulations suggest that in support of your application, you will be required to submit such an evidence to suggest the starting point will be that you have met your sponsor. You need to establish the dates on which you met your sponsor. Then it says that the relationship between applicant and their partner must be genuine and subsisting. So the evidence to that could be a marriage certificate or any other relevant documents. So, for instance, you have been living in your country of residence or country of nationality and your sponsor or your partner had been living in the UK, but they might have been visiting you during this time of relationship. They could be engagement ceremonies, they could be marriage ceremonies, they could be reception ceremonies that might have been conducted in your country of residence and country of nationality. So you need to establish through photographs taken on your marriage, or maybe photographs taken on your holidays away from the UK or your country of nationality, in a third country where you might have met each other. So all that evidence is required in order to establish that part of the application. If the applicant and partner are married or in a civil partnership, it must be a valid marriage. So the evidence for your relationship is a valid marriage, or in case of a dual relationship where there are unmarried partners, you need to establish that you are in relationship for at least 2 years prior to making the application. And there is a separate list of documents that could be available to you if you look at the Home Office website, or you can look at a subsequent regulation, which is available in a separate regulation called Appendix FMSE. So, all those documents that are defined in Appendix FMSE, if you do not submit those relevant documents and your application gets refused, then it will be very difficult for you to win an appeal if you are granted a right of appeal against such a refusal. Then, when it talks about fiancés, you can also submit the application being a fiancé of someone who is in the UK. And if you do that, you will have to meet the relevant eligibility requirement under Appendix FM. There is a difference between a fiancé application or a simple marriage visit visa application. Primarily, if you enter in the UK as a fiancé, and you meet the relationship requirement, the financial requirements, the English language requirement, then once you are in the UK and you register your marriage in the UK within 6 months, you will be able to switch into a spouse visa application without having to leave the UK, and you can make an application for further leave to remain in the UK, as compared to a simple marriage visit visa application where you're required to come into the UK, register your marriage, go back to your country of residence or nationality, and submit a fresh application for entry clearance as a spouse. So it saves a lot of your time and energy, and also it is a very hasty process, which is financially also very burdensome. So you need to be establishing whether you need to submit an application as a fiance, or you want to first make an application as a marriage visitor. Then it says that any previous relationship of the applicant or their partner must have been broken permanently. So if you have been married in your past life before you entered into this current relationship, you need to establish it through a decree absolute or a divorce decision made by any country where you have been residing in. So to establish that any past relationship has been completely broken down, and this is the relationship that you are in for which you are submitting application. Uh, um, the applicant and partner must intend to live together permanently in the UK. So you need to establish that you are permanently deciding that you will be residing with your sponsor in the UK on the basis of your permanent residence, and your intentions are paramount in this. Home Office has to be satisfied that you really intend to stay in the UK with your spouse permanently before you submit such an application. If that intention is not established, there may be chances of a refusal. So it is a very important bit in your application. You can also submit a cover letter explaining the entire situation with your relationship to establish to the Home Office that you really intend to spend majority of your life in the UK with your sponsor. Uh, Next, there are financial requirements that you need to look at. Right. So the next eligibility requirement under this application for entry clearance as a spouse, you need to meet the English language requirement. English language requirement is fundamental in a sense that Home Office introduced new guidelines on public interest considerations, and one of the public interest consideration in such regulations were that the applicant is able to speak fluently in English so that it gives less of a burden to the public purse. Where, for instance, um, if you're living in the UK and you're required to attend a court proceeding, if you do not speak in English, then the relevant public body would have to pay to a third party to come as an interpreter and interpret it to the relevant public body, whatever you're speaking in your own language. So, for instance, if you speak in Punjabi and you are required to give evidence in the court of law, at that point, that relevant court will have to instruct an interpreter to come to that proceedings and interpret it to the court, whatever you are trying to establish during any proceedings before a court of law. So it is good in a sense that you will be able to meet and greet people, make your friends in the UK while you stay in the UK. So it is paramount that you can at least speak or listen English in a recognizable way or a basic way that you will be able to communicate to other people who are residing in the UK and you consider UK as your home. So the law suggests here that the applicant must provide specified evidence that they are a national of a majority English speaking country listed in paragraph journal 1.6. Now, this is the first requirement uh, under this eligibility requirements. If you are a national of majority English speaking country, so for instance, if you are a national of USA or Australia or maybe Jamaica, then you are not required to produce any other evidence to establish that you can speak in English. So the list is available online. You can just simply Google list of majority English speaking countries. And if you are a national of that particular country, all you need to do is to produce a passport of that country, which will establish that you don't need any other evidence to establish your English language skills. Next in line is that the applicant have passed an English language test in speaking and listening at a minimum of level A1 of the Common European Framework of Reference for Languages with a provided approved by the Secretary of State. Again, in these circumstances, if you are not a national of majority English language countries, then you will of course need to pass an English language test, which is um, approved by the Secretary of State. So again, you can Google simply the list of English language providers in your country of origin. Commonly, it is known as IELTS, International English Language Training System, through UKVI. And as you have to pass it level A1 only in speaking and listening. So that means that there may be an interview conducted by the relevant public body. You go to the interview, you are asked some questions, or you are given some scenarios to speak about, so to establish that your listening and speaking is up to the very basic, because it's level A1, which is very basic. It is easy to be performed, and you can study towards your assessment for that matter. You can simply Google British High Commission or British Council in your country of residence and see when is the next date of assessment available online. Before that, you can prepare for your test, and if you pass, they will be giving you a certificate to suggest whether you have passed it at level A1 or you have failed it. If you have failed it, unfortunately, you have to take it again to establish that you can speak and listen English. The third requirement is that the applicant have an academic qualification which is either a bachelor's or master's degree or PhD awarded by an educational establishment in the UK, or if awarded by an educational establishment outside the UK, is deemed by ACTIS to meet or exceed the recognized standard of a bachelor's or master's degree or PhD in the UK, and ACTIS has confirmed that the degree was taught or researched in English to level A1 of the Common European Framework of Reference for Languages or above. So, in a nutshell, if you have done a bachelor's or a master's or a PhD degree in the UK, you don't need to go to any other public body who could establish whether it is equivalent to level A1, because that is the defined evidence that you can put with your application. But if you have done your degree in bachelor's or master's or PhD in your country of residence or any other third country which is not regarded as the English language speaking countries, then there's a body which is called ACTIS. Uh, Formerly, it used to be called UK NARIC, but they have given it a new name. You can go online and then produce such evidence which ACTIS requires you to produce in order to establish whether the degree that you have done in your country of nationality or residence is equivalent to UK's bachelor's, master's, or PhD, or it is equivalent to level A1 of the European framework, Common European Framework of Reference for Languages or above. So they may be charging you for these services. They may also ask you to produce a letter from the university or colleges that you have done your bachelor from to establish whether the degree that was taught to you was primarily in English, or are exempt from English language requirement under paragraph 4.2. So there are exceptions that are available for people who do not meet the English language criteria and under the general requirements. 4.2 suggests that the applicant is exempt from the English language requirement if at the date of application the applicant is age 65 or over. So there have been very rare applications that I've been doing in the past where the applicant was over the age of 65. Um, but if in this circumstances, as the case could be varied on different situations or scenarios, if you being an applicant are over the age of 65, then there's a good news that you are exempted from English language requirement. Um, Subsection B says that the applicant has a disability, physical or mental condition, which prevents the applicant from meeting the requirement. So, um, as you can see, it is self-explanatory. If you have got physical or mental condition which prevents you to take the test, then you will have to establish through corroborating evidence to establish what kind of mental or physical disability you have, which prevents you to take the exam. Uh, in my experience, I have dealt with people who were deaf and dumb. Naturally, in those circumstances, we produce the relevant evidence as to why the applicant is unable to take the test, and you will need to establish that through actual reliable evidence when you submit your application. Or there are exceptional circumstances which prevent the applicant from being able to meet the requirements prior to entry to the UK. So any exceptional circumstances. It could be anything, but it shouldn't be that you fear taking the test. That is not an exception. If you are hesitant to take an exam, that will not be regarded as exceptional circumstances. It has to be a valid evidence and a valid reason why you cannot take the test and why you cannot produce such an evidence with your application. So, looking at the entire immigration rules for entry clearance application, uh, these are the fundamental requirements, including suitability requirements and eligibility requirements that you need to meet before you make an application for entry clearance. Um, I hope I have defined the rules in a very simple and basic way so to help you establish whether you meet the requirements. Your comments will be very helpful in order to establish whether there will be a need of further applications to be discussed through these medium of having videos prepared. It is also requested that if you like the video, you can also subscribe our channel, and so that you could be updated with any further videos that we prepare. But just before I complete this video, I will try to summarize the points that we have discussed. Although this video is um, relevantly longer, but hopefully this will help you prepare your applications in a very fine manner so that you get your results accordingly and you meet your spouse in the UK. So let's have a brief overview of all the video that we have prepared in a short while. So, for the summary of whatever we have discussed in the video, again, first of all, you need to establish that you are outside the UK, you are residing in your country of origin or your country of nationality, that you have made a valid application to the relevant public body and submitted the application in accordance with the relevant regulations. For that, we discussed about various ways of submitting applications from outside the UK. You submit an application for Appendix FM under the partner rules. Once you give your the country of nationality or your residence in the UK, you identify the location where you have to take your biometrics and in a particular city of your country of residence or nationality. Then you submit and click on this button, which is asking you to apply now. You apply through starting a new application. Then you provide a relevant email address in order to register yourself for the application. You complete the application with the relevant information that the Home Office requires from you, which includes your personal information, your financial requirements, documents that you need to establish your financial and your personal circumstances. Then you declare and pay the relevant fee. After you pay the fee, you then book an appointment for you to go and enroll your biometrics. At this stage, when you enroll your biometrics or upload your documents at the relevant portal, it is advisable that you complete a helpful cover letter for the Home Office as to establish all the relevant laws that we have discussed if you are a representative of any such applicant, if you're a solicitor or an advisor with the Office of Immigration Services Commissioner, and if you want to start practicing as one. So it is very helpful that you provide that cover letter with your application. Under these circumstances, then you will have to establish your whether you meet the suitability criteria. In essence, suitability is that you do not have any past criminal convictions, you have not lied to the Home Office before, or you have not overstayed or misrepresented the Home Office, and you do not owe any money to the public body in terms of litigation cost towards Home Office or uh, cost towards NHS from any of your past treatment with the NHS. Then you come to the eligibility requirements, in which you first of all meet the relationship requirement. You have to establish that you have met your partner, that you both are married, or if you are unmarried, then you need to establish that you are in a relationship for 2 years at least. You need to produce your marriage certificate. Also, you need to establish that your relationship is subsisting and genuine. All that evidence that we discussed earlier need to be produced before the Home Office in order to establish that you have got a genuine and subsisting relationship. If you're submitting an application as a fiance, you will be able to switch to a spouse visa without having to leave the UK. Or otherwise, if you have got a marriage visit visa application approved, after your marriage visit visa or the marriage registered in the UK, you would have to leave the UK, go to the country of origin, and make an entry clearance application for that matter. Then, in terms of financial circumstances, we discussed that your sponsor needs to establish that the sponsor is earning £18,600 from a particular source that we discussed under Appendix FM 1.7, a policy guidance that has been established by the Home Office. Otherwise, whether the sponsor can combine with other source of income, that is also provided in the policy guidance. Then there are some exceptions to the general rule. If you're getting any such allowance from any disability, you will need to produce relevant evidence. In these circumstances, you have to um, establish that you will be able to maintain and accommodate yourself without recourse to public funds. You will have to provide a house survey report to establish that the house that you're going to live in will not be overcrowded or will contravene the public health policies for that matter. Then you need to come to an English language requirement. You can have an evidence to establish that you are from majority English speaking country. B, that you need to pass an English language test which is equivalent to level A1 of a common European framework. C is that you are either exempt from taking such test because you have got a bachelor's or a master's degree which is equivalent to UK's bachelor's master's degree, or which is equivalent to level A1 after you get it um, complied by the body called ACTIS, as I discussed earlier. Then there are exceptions available. If you are over the age of 65, then you are exempted to produce any such evidence. If there is mental or physical disability, you will have to produce an evidence to establish that. And if there are any other circumstances which prevents you to take the test, you will have to produce that evidence in accordance with the immigration rules. So that was a quick overview of what we have discussed in this video. Again, if you like the video, you can subscribe our channel, like, and also share with people who want to submit an application, or if you want to seek an independent advice from a solicitor or an advisor regulated with Office of Immigration Services Commissioner, it is advisable that you book a session with that relevant solicitor or advisor who can assist you accordingly, looking at your circumstances. With that, I beg leave, and I hope that I have assisted in any manner which could help you in your applications for entry clearance as a spouse of a British citizen or someone who is settled in the UK. Thank you so much. Bye.